Hey guys, welcome to my legal classes. This is Ganesh Pujari and we were discussing chapter 5 from Indian Penal Code, which is all about abetment. And in this series, this is my fourth and last video. We have already discussed from section 107 to 116, and here I am going to discuss the last four sections starting from section 117 to 120. In my first video, I have explained what is abetment and abetter, and then the last two videos I have explained what are the punishment provisions. Here I am going to deal with the remaining punishment provisions as far as abetment is concerned, and why to waste time, let's get into the first section, that is section number 117. I hope you have watched my earlier three videos, and if you have watched, by now you should have by hearted three important keywords as far as abetment is concerned. What are they? Instigating, engaging, or aiding. Now for abetment, at least one among these three is essential. Now A is instigating B, or A is engaging B, or A is aiding B to do something to Mr. Z. That is the illustration that we have discussed in my earlier videos, and I have given hell lot of illustrations and case laws, so we will not get into that. But here what happens, A, instead of instigating, engaging, or aiding Mr. B or several other person, the change is here there are minimum 10 people or public in general. That is the only change that we have to remember when it comes to section 117. In all our earlier cases, we have discussed with one or two people, but what happens if the people who got abated, abetter is only one, the same A, but the people who got abated here are minimum 10 or more or public in general. Now A doesn't like Z. Now what he does, there are few people and he says go and hit Mr. Z. He is instigating all of them. Now we don't know the count, they are public in general. Or if there are more than 10 people and if A is abetting or instigating, aiding or engaging 10 or more people to hurt Mr. Z, that is more than 10 members or public in general, and there the punishment can go up to 3 years of imprisonment or fine or both. That is all. Nothing can be easier than this. So there the only difference is number of people who got abated. Now everything else remains same, instigation, aiding, engaging, everything remains same except for the number of people who got abated are 10 or more people or public in general. And then I have already told the punishment provisions. Now what happens with the CRPC provisions? It is same with the offense. If the offense is cognizable, then the abetting of this act, which is under 117 section, the act will also be cognizable. Likewise, the bailable or who is trial or who is conducting the trial, all that remains same as to the offense, and these are non-compoundable offense. That's all you need to remember as far as section 117 is concerned. I missed one information from section 117, that there can be 10 or more people or public in general or any class of people. This class of people is very important because most of the time section 117 comes into place when there is an abetment against a particular religious activity, etc. Now someone can abet a certain number of people or class of people against another community or another religion, etc. That is why the class of people is very important. And remember, there is a beautiful illustration available in my previous slide, so you can take the screenshot and go through that illustration also, which is quite clear as far as section 117 is considered. With that, let's get into section 118. Section 118 discusses about concealing design to commit offense punishable with death or imprisonment for life. Here what happens, there are two major ingredients. One, there is an offense which is going to take place which is punishable with death or imprisonment for life, and there is a person who knows that this is going to happen but he is concealing such design. Now what happens in that case? The provision reads, whoever intending to facilitate or knowing it to be likely that he will thereby facilitate. Now it can be with the intention or by knowing it to be likely that he will thereby facilitate the commission of an offense punishable with death or imprisonment for life voluntarily conceals by any act or illegal omission the existence of a design to commit such offense or makes any representation which he knows to be false respecting such design. Here what happens? The person knows that that particular offense is going to happen which is punishable with death or imprisonment for life, but he intentionally facilitates such act, or he, by being silent, though he is aware, by being silent facilitates that commission of act. Now in that case he is also punishable. Now before getting into the punishment, let us try understand the entire scenario with an illustration. Now there is one Mr. A and he is very much aware that there is a place called B where there is a dacoity is going to happen. But A does informs a magistrate that there can be a dacoity happens at place C. Now he intentionally diverts the concentration of magistrate towards C so that he is facilitating the dacoity at place B, because magistrate makes all arrangement to stop dacoity at place C. Now all the sources have gone to place C, so dacoity at place B becomes very easy. Now who has aided that? It is A. Now he is punishable under section 118. Here the person either intentionally conceals or intentionally facilitates for such offense. That is what you need to remember. And in the end, if the offense is being committed which is punishable with either death or imprisonment for life, in that case for concealing the punishment can go up to imprisonment of 7 years along with fine, and if the offense is not committed then it can go up to imprisonment of 3 years along with fine. And as far as CRPC provisions are concerned, it all goes with same as offense, like the cognizable or the bailable, non-bailable, or who will trial. All of that goes same as to the offense. And one another aspect you need to remember, if the offense is not committed, in that case the offenses are bailable. And here the offenses are non-compoundable offenses. With that I am moving to section 119. Section 119 is the continuation of section 118, where in 118 we are discussing about the concealing of design by the general public, whereas here we are discussing about the concealing of design by a public servant. Now what happens here? Public servant concealing design to commit offense which it is his duty to prevent. Section 119 is the continuation of section 118. Under section 118 we are discussing about concealing of design by a general public, whereas here we are discussing the same aspect which is done by a public servant. It says public servant concealing design to commit offense which it is his duty to prevent. There are two important parts here. One, the public servant has the duty to prevent such an offense, but he himself is concealing the design. Now the provision reads, whoever being a public servant intending to facilitate or knowing it to be likely that he will thereby facilitate the commission of an offense which it is his duty as such public servant to prevent, voluntarily conceals by any act or illegal omission the existence of a design to commit such offense or make any representation which he knows to be false respecting such design. Here we have to observe two things. One, he is intentionally facilitating, or by being silent he is facilitating the commission of offense. On the other hand, he may do an act to support that offense, or by being silent itself he can support that particular act. That is how we have to see. Here there is an illustration where there is a police officer by name A, and his duty to give information if there is any robbery is going to happen. But though A is aware that B is going to commit a robbery, he is not giving information to anyone. Here he conceals such design, and by that way he is punishable under this particular provision. Punishment can be seen in three different ways. If such offense is already been committed, in that case the public servant will get the imprisonment up to the half of that particular offense along with the fine. And if the offense is punishable with death, in that case the imprisonment can go up to 10 years, and the cases there are non-bailable cases. and if the offense is not been committed, in that case the punishment will be 1/4 of the imprisonment or fine of that particular offense or both. So if it is been committed, in that case half of the imprisonment along with fine, both are half, and if the offense is not committed, in that case both are 1/4, that is 1/4 of imprisonment or 1/4 of fine or of both, and if the offense is punishable with death, in that case imprisonment up to 10 years. That is what we need to remember. Other than that, all the CRPC provisions are going along with the provisions that are related to the offense that is going to happen or been committed. Here comes the last section, that is section 120, which is again continuation of section 118. There we are discussing about the concealing of design, which is punishable with death or imprisonment. There the offense is punishable with death or life imprisonment. Here the only change is it is not punishable with death or life imprisonment, and it is just imprisonment. In that case, what happens? For concealing design to commit offense punishable with imprisonment, if such commencement of offense is completed, in that case the punishment for the person who is concealing will be 1/4 of the imprisonment of the offense or the fine of such offense, and if the same is not been committed, in that case 1/8 of the imprisonment for that particular offense or 1/8 of the fine or same. So that's all you need to remember. Here the punishment for that particular offense is only punishment. If it is death punishment or life imprisonment, we are referring section 118, and if it is only imprisonment, then we are referring section 120. Other than that, section 118 and 120 remain same. I hope that is very clear. And as far as punishment is concerned, I will repeat, if the offense is already been committed, in that case it is the punishment, that is 1/4 of the punishment which is available for the offense, and if the offense is not been committed, in that case it will be 1/8 of the punishment. With that, I am concluding the series on the chapter Abetment. Let me see you with the chapter 5A from my next class. Till then, thank you so much if you have already subscribed my channel. If not, this is your time to subscribe my channel. Please like, share and comment my videos. All the very best for whatsoever purpose you are referring my channel, and thanks again.